Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpong and I am your host.
It's the start of a new month. April is here. And we're stepping into the new month with confidence. And that's what BWF Solicitors is saying, that they stand with you in every case, every time. My name is Oreku Frimpong and welcome to another edition of The Community and the Law, brought to you by BWF Solicitors, our trusted partners when it comes to the law. We're going to look at how to successfully apply for an EUSS settled status under retention of rights. Remember, we've looked at what retention of rights is, how you actually enjoy that privilege and what you do to get into that situation. Now, today we're taking it a step further and we're looking at how to successfully make an application for an EUSS settled status. BWF Solicitors has made it possible for us to have Lawyer Charles Asma to be our resource person and guest. And he's going to take us through all that and all the questions that you would have to pose, what things that are bothering your mind, all the concerns you have, bring them over, and Lawyer Charles Asma will be ready to handle them. BWF Solicitors, they're located on the 4th floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters in North London. You can call them 0208 493 7340 Monday to Friday, and you will have the benefit of their professional and good quality service. This afternoon, we're live on BWTV, as I mentioned earlier on, and you can catch us live on BWTV and at BWF Solicitors, both on Facebook and YouTube, at BWF Solicitors and at BWTV UK. My name, once again, is Oreku Frimpong. Welcome to the show.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, and thank you for sticking around as live on BWTV. And the program is The Community and the Law. Let's first of all do some housekeeping. If you joined us, we are live at BWF Solicitors on Facebook and YouTube, and at BWTV, both on Facebook and YouTube. And when you do join us, please like the page, share, and comment. The first of all, the first comment, so to speak, that I would want you to put on is to say hello and welcome somebody to the program. And then again, I would want to introduce, as I mentioned earlier on, our resource person and guest, Lawyer Charles Asma, who's going to lead us in that very interesting discussion on EU settlement scheme and retention of rights. Lawyer Asma, good afternoon.
Good afternoon, Brakuku.
How are you doing, boss?
Very well. How are you too?
I'm very well, thank you. And we thank God for mercies. Well, we've entered into a new month, and I believe that it's the start of new things, because obviously we're entering into a new side of the whole season here in the UK. There was one day in the week earlier where we have all 4 seasons. There were snow falls, there was sunshine, it was raining, and it became so very dry. But at least now God has given us the opportunity to enjoy only one of that. So deep into spring, as it were. How are you feeling? What do you have for our listeners, our viewers, and of course clients as a welcome?
Thank you very much, viewers and listeners, and Christians all over the world. Happy Easter season. Season of sacrifice, season of kindness, season of positive outlook. And so during this program, we'll be looking at how best to inspire and give hope to those who feel that they've gotten to the end of the journey as far as the immigration and journey in the UK is concerned. There is still hope. And even if you think that it's all over, remember, Easter resurrection gives hope and assurance that it is still not over.
Well, and then I will, based on that, express some appreciations. We've got some from in-house, and of course, one from outside of the family or the building. We will first of all say thank you to the community for supporting us when our sister, our partner, and our mother, Eunice, lost her mother. The family is saying thank you for your heartfelt sympathy, your love, the support, the gifts, and of course your presence during this difficult time. In fact, they continue to say that your kindness has provided comfort and strength to the family. So they say, God bless you. This is from the Akumi and Hasford families, and that's the late mother of Lawyer Eunice. As we all know, Lawyer Eunice is a partner of BWF Solicitors. So on behalf of Lawyer Eunice, to everybody out there, to members of staff, to everybody that contributed one way or the other to comfort the family, we want to say thank you. We're so grateful. God bless you all. So the family says thank you, and I'm reiterating that as well. Interestingly, the day after the Thanksgiving service for the late mom's passing, Lawyer celebrated her birthday. And of course, whatever happens, we give thanks and praise to God. And it always ends on a positive and a good note. So we would want to take this opportunity as well to wish Lawyer Eunice, solicitor and partner of BWF Solicitors, a very blessed birthday. We wish you continued excellence and success in your legal career as a distinguished solicitor and partner. Well, we're saying that may this new year bring you greater achievements, good health, lasting happiness, and more encouragement in the Lord. Happy birthday to you, Eunice. At this point, Lasma, I would ask you to come in so you join me to say happy birthday to our dear sister.
Yes, so Lawyer Eunice, on the occasion of your birthday, we have already celebrated you, and this is the time the community gets to celebrate with you as well. And we join the community, we join family, we join friends here near far and near to wish you the best of everything in the coming year. May your God continue to order your steps. And we know that you have so much to offer the community, and we pray that your wisdom, knowledge will continue to abound so that the community will benefit from that. Have a happy birthday, Lawyer Eunice.
Well, thank you very much, and that's very heartfelt. And we have Sandra Fraser being nominated and voted for as the Employee of the Month of March 2026. So, Sandra, thank you very much. I know pretty soon when we pick up the comments from the comment section, either on Facebook or YouTube, you would see that she would have directed people to come in to join the show. She would have directed people to visit the office. She handles the front desk. She's the manager of the front desk, and she gives you that smile and the warmth of a welcome. So, Employee of the Month, congratulations to you, Sandra Fraser. We salute you, and we believe that you continue to do everything that will make people love and have a lot more confidence in BWF Solicitors. So, congratulations to you. We salute you, we doff our hat to you, and we say, keep it going. Sandra Fraser, congratulations. Employee of the Month of March 2026. Now, Kofi comes in with this very interesting feedback for us. Uncle Charles, I want to share that with other viewers and the family in BWF Solicitors. Now, Kofi says that his visa was due to expire, and he was so worried and emotionally and mentally down. Then he chanced on a video of Uncle Ben, Mr. Bernardo Wusu, that the lead counsel for BWF Solicitors, as he said that, and he found out on Facebook. Took the contact, called, and booked an appointment the next day. The best part of it was he spoke in a local Ghanaian dialect, which made it much easier for him to air his concerns. He continues to say that he really enjoyed the atmosphere, very friendly and welcoming. The employees were so friendly and welcoming. They gave him the cost, which to him was quite moderate, and he immediately made payment. The process started, and in November 2025, by February 2026, boom, the good news came. He is strongly recommending BWF Solicitors for all immigration advice. So people, Kofi is leading the way and is showing you that if you trust BWF Solicitors, you trust that your case will be resolved. And he says, thank you to you, Uncle Ben, and the team. Uncle Charles, thank you to you and the team as well from Kofi.
Yes, yeah. So Kofi is one of the many members of the community who continue to enjoy the wisdom, knowledge, the skillfulness, the experience, the fortitude, and the analytical abilities of BWF solicitors. As community lawyers, we understand the specific needs of the community members and we tailor our approach to meet that need. And that is why, even though Kofi was worried, dejected, and felt that all was over, we're able to bring him back to life as far as his visa was concerned. And he's saying, boom. Boom simply means that, hey, beyond imagination, beyond expectation. So we exceeded above and beyond. So this is from Kofi, but you will be next to give your testimony. Give us a shout, and you'll be smiling.
Well, the smile will be so broad. So, yes, follow Kofi's footsteps and join BWF Solicitors. You can get BWF Solicitors on the fourth floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters in North London. Call and book an appointment. Remember, they work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. The numbers, as you find on the screen, 0208 493 7340 0208 493 7340. And those of you in Ghana, there's an office in Ghana where you can either pop in, call them, and make use of the services of BWF solicitors. They are on 055 589 5959 055 589 5959. And in all emergency situations, there's mobile number that you can call, text, or send a WhatsApp message to plus 4477 127 61884 plus 4477 127 61884. You can visit BWF Solicitors at their website, www.bwfsolicitors.com, or all the social media platforms at BWF Solicitors. Okay, now let's get to learn something this afternoon. It is a criminal offense to provide immigration advice or services in the UK if you are not regulated or otherwise qualified to do so. This is timely information. This is cogent advice. This is something that we would all need to take note of. Why? The details will be coming as well. Asma will be helping us unveil. Unqualified individuals offering such advice can face imprisonment and fines as specified below. So I've got two situations here I'm going to bring on. A, on summary conviction to imprisonment for a term not exceeding 6 months or to a fine not exceeding the statutory maximum, or to both on conviction of indictment, that's the second one, to imprisonment for a term not exceeding 2 years or to a fine, or to both. This is from section 84.1 and 91.1a and b of the Immigration and Asylum Act of 1999. I am giving you this caution. People are doing that. Sometimes we refer to them as the pocket lawyers, the car boot lawyers who would meet you at McDonald's, open the car booth. The next moment, they send you an email. You reply to it, and you don't even get a response. Home Office will respond to something about you, and the person is gone. Spent your money on all that. And sometimes too, they may make mistakes. They may not give you the correct advice. Me, I'm a communication and a media person, so I always hide behind BWF solicitors so that they will give you advice and I'll propel it to you. I think I'm doing the right thing. You may not be doing it. So let's get some details as to how we can identify those who are doing the wrong thing and those who are doing it right. Uncle Charles.
Yes, yes. So this is important because oftentimes somebody will call us and say that lawyer, I can't find a lawyer. I can't find a person. I can't, and I'll ask, do you have a copy of the application form that was submitted? Person will say no. Have you contacted a lawyer? Oh yes, I go there. There's nobody, and Sometimes they will check the application form only to even realize that the name there is their own name. And if the name there is your own name, it means that you did the application yourself. So we cannot trace it to anybody. And again, for people who do that, this is the caution, because it takes somebody who is disgruntled to take action against you. And once such action is taken against you, the law is clear. If you are not qualified, you cannot provide immigration advice. Because immigration advice is a regulated activity, so to speak, in the UK. Regulated in a sense that because of the nature of the service, people are so worried. People are, and whatever you tell people, they would accept and take it, especially if you present yourself as a lawyer. And that's why the law is very clear. So, who qualifies to, one, provide immigration advice, and two, provide immigration service? One, somebody who is a qualified, licensed solicitor in the UK, or somebody who is qualified, licensed barrister in the UK, or somebody who is licensed under the OISC programs or provision, that is Office for Immigration Services Commission, accredited providers of immigration service and support. Yes, they are also able to do that. And the last group is SILEX professionals. That's the Chartered Institute of Legal Executives. Chartered Institute of Legal Executive Professionals. So if you hold SILEX qualification, you can. If you have license from OISC as a provider, either level 1, level 2, level 3, to be able to give immigration advice, yes. If you're a solicitor, yes. If you're a barrister, yes. Apart from that, you cannot. And if you do, the law is clear. Once you are caught to have done it, that is called summary conviction, in a sense that, for example, magistrate court, you are summarily convicted, there's no escape, where you say that, okay, yes, I'm guilty, I have done it, there's no escape, then that may call for imprisonment or a fine. And where we have to go beyond and prove that you did it or not, then that's conviction on indictment, where you have more or less done something dubious. That's an indictable offense. In this case, once you are convicted under indictment, it becomes even serious. There's even more severe punishment. Imprisonment is also it's always an option, and you don't want to go to prison simply because you gave advice to somebody. Either you did it freely or you collected money or at a fee. You have done it, and why will you have to put yourself in that situation? So those of us who are not qualified but are giving advice, let's be careful, because the law is only active once you find yourself in its arms.
So let me ask and put myself in this situation. For instance, somebody calls me and says that I would want to put in an application XYZ, and this is what I have done. Can you glance over it for me? And I do glance over that, but then I would say, don't take my advice. Go and speak to lawyer XYZ, who is duly accredited to do that. Would I have absolved myself of any how do I put it? Would I absolve myself of not committing any offense?
Yes, you have. You would have. So you would have absorbed yourself, because obviously you were only helping to go through, maybe check grammar, spelling, factors. Just like somebody writes and say, can you look over for me? Because reading my own script, I may not be able to pick up the errors. So that's fine. But if the person said, can you look at it and tell me if I'm right or wrong, then you are going beyond just going through and to offer advice.
Okay.
And that's why, even if you realize, councils, even home office, and so on and so forth, sometimes they will, when they are writing to clients or individual, they will tell them that you need to seek independent immigration advice.
Okay.
Even they will not tell you that this is it if you speak to them, because they know that they are not potentially qualified to give advice. And so
Mhm.
if they did and something happened, you will always quote them. So they will tell you, go and get independent advice. Just like if
Yeah.
you come to me and tell me that, lawyer, I want to take a mortgage or I want to take up insurance. Will you advise me? You are a lawyer. I'll tell you, I'm not licensed to give financial services and insurance
Yeah.
advice,
Nice.
because you
Okay.
have to, yeah. So it's as simple as that. So you are right. If somebody came to you, but the law says that if you are making a referral, that's fine. You can refer.
Mhm.
Referral is fine. But the key thing is advice and representation. It's what you are doing in the form of advice. If not, then you are not in trouble. Are you representing the person? If not, then you are not in trouble. But if it's
Okay.
a form of advice, where the person comes to you, you talk to them about it and say, oh, okay, these are the things you need. We'll do it this way. And then you are advising the person. So,
Mhm.
so what you said, no, that one you don't have a problem. If you are just going over the form to check spelling mistakes and so on and so forth.
Okay. So yes, ladies and gentlemen, sections 84(1) and 91(1)(a) and B of the Immigration and Asylum Act of 1999 says that it is a criminal offense to provide immigration advice or services in the UK if you are not regulated or otherwise qualified to do so. A word to the wise is always enough. So take note. And I would reiterate what I always say, that it is always best for a layman to give their job, for an artisan to do for them. These people have qualified, they have been regulated, and they are recognized as such. So go to them as a friend Kofi did, and he comes in to say, boom, if you needed anything, go to BWF Solicitors. He signposts you to the right place, and I will signpost you to the right place as well. BWF Solicitors, 214 to 218, Tottenham High Road, Seven Sisters in North London, 0208 493 7340. Now, based on this nugget, let me test your knowledge to see if you really understood or you took it on. Peter is a law graduate, okay? He's been advising people in the community on immigration matters. He takes up cases by completing and submitting applications for people, often at a fee. On one occasion, he advised Sarah about an EUSS application and agreed to submit Sarah's application for her. Sarah's application was rejected because there was no reasonable ground for delaying the EUSS application until July 2025. Sarah has raised a complaint against Peter for the rejection of her application. You see, somebody did it for her, it's been rejected, and now I'm going to complain. I'm going to report Peter. So help me advise Peter. I've got three scenarios. It is not Peter's fault that Sarah did not have any good reason for the delay in submitting their EUSS application. That's one. So you can tell Peter that. Or do you want to tell Peter and say, if Peter, you can show that you advise Sarah about the likely rejection, you should be all right. So the second one is, if Peter can show that he advised Sarah about the likely rejection, then Peter should be all right. Or would the advice be that Peter has committed a criminal offense and is likely to face imprisonment or a fine, or both, because he provided an immigration service when he was not qualified to do so? So juxtapose that to the nugget and the explanation that lawyer Charles Asma is giving, and the nugget, and see what advice you can give out of these three options I have given you. In the meantime, Alex will say thank you very much for your compliment. Thank you. It's by the grace of God, you know. Tilly Duma is on and asking Nanette Ahin to come on board. Giacomo2676 says, can I ask my question in P when I call? Yes, of course. If that will make you comfortable and you will sail your boat, that's fine. We can do a translation of that for those viewers and listeners who do not understand language. Besma Jamina, hello to you as well. Thank you very much for joining us. We have Mumin Abubakar. Good afternoon to you as well, Mumin. How are you doing? Hope you are so very well. Barika de Salah if you did celebrate that. Looking great, Kweku. Oh, thank you, Alex. As I mentioned earlier on, I acknowledge that thank you. It's by the grace of God. I don't mind Alex. I mean, not doing it. Well, then Ade Safo says that congratulations to Sandra for winning the Employee of the Month. That will come up. Then I my senior minister, bruh. The class is ongoing. This is from Tini Duma doing what she does best. And I believe that when you are on as well, you put your comments in the comment section down below, either on Facebook or YouTube, to allow people to see and feel what it is that we are cooking and dishing out here on the program, The Community and the Law, brought to you by BWF Solicitors on BWTV. After this quick break, we'll come back and we will get Lawyer Charles Asma to lead us into that discussion on the questioning or the topic how to successfully apply for an EU settled status under the retention of rights. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And welcome back. Thank you very much for sticking around. We're live on BWTV, and the program is The Community and the Law. It is brought to you by BWF Solicitors, our trusted partners when it comes to the law. How to successfully apply for an EU settled status under the retention of rights. That's what we're going to look at. So sit back, relax, because the discussion is going to be very methodical, very extensive, and it will help you look at some strategies to look at this when it is that you have to put an application like that. And as I said, BWF Solicitors is helping us do that. We want to say thank you to them, and also say thank you to Lawyer Charles Asma for spending time with us this afternoon. Lawyer Asma, good afternoon once again. EUSS application, retention of rights. I quite remember a few weeks back, we kind of looked at the retention of rights and what circumstances under which people can retain those rights as EUSS, let me say EU citizens under the EUSS scheme. Let me put it that way. I'm not a lawyer, so allow me. We are just rattling with some of the terms and the technicalities. But yes, retention of rights and successful applications. How do we marry the two, and how do we unpick them, and also look at who qualifies under those?
Sure. Right. Yes. So we today we're looking at retention of rights, and we will look at the law governing that. Why
Mhm.
is this something that is available? Who is this available for? And what
Mhm.
are the nitty-gritties? So every EU national has a right. Prior to Brexit, every EU national had a right to move freely to other EU countries, as far
Mhm.
as that country was part of the EU bloc.
Okay.
Then what it means is that that person who is the EU national has a right of free movement.
Mhm.
And that right covered all their family members, both extended and nuclear or direct. So the right they had extended to their families, and we call it EU nationals' right.
Okay.
Then on the 11th of at 11 p.m. on 31st of December 2020, Britain left the UK, the EU. Britain left the EU. And so all those who are EU nationals or who were EU nationals could no longer enter UK freely because that right could not be used within UK. What about those people who had already exercised such right? Would their rights be taken away? And so Britain and EU came into agreement, and they called it the Withdrawal Agreement Act 2020. And the Withdrawal Agreement Act 2020 spelled out what the rights will be after Brexit. And so the conclusion was that members whose nationals were already living in the UK with their family members will have their rights protected. And the word to use in place of protected is retained. Hence, retention of right.
Okay.
Retention of right.
Right.
And the
Okay.
particular rule or regulation is Regulation 10 within the agreement, Regulation 10. And so, Regulation 10 looks at how that right, which existed before Brexit, could be protected or retained.
Okay.
And so the policy guidance for caseworkers was couched in 2020, wherein caseworkers became clear what constitutes retained right and
Okay.
what does not constitute. And so anytime somebody came to say that even though I'm no longer with my family member, I have retained my right, they must prove it. And
Mhm.
so they said that if anybody wanted to prove that they have retained a right, they have to show that they are no longer with that family member.
Okay.
But they had the right before they left that family member.
Okay.
And so if you have a family member, how do you become a family member of somebody? Brakweku, how do you become a family member of somebody? Starting with
So
the
it's
basic.
either through relationship, that is either through marriage, or you are dependent on the person, where the person is taking care of you, taking care of all your um, physical, spiritual, and emotional needs, food, clothing, and shelter, I presume.
But okay, so if somebody is looking after you,
Hmm.
the person may only be a caretaker, not necessarily a family member.
Okay.
And as you said, family member is perhaps based on relationship established. And the
Okay.
relationship here, we're looking at two angles of relationship. Two angles. The
So
first
then we can
angle,
say parental relationship and marital relationship.
exactly. So let's drill the parental down. What is the
Okay.
basis of parentage?
Mm-hmm.
Birth, isn't it?
Beth,
Birth.
yes.
So B and D. So the two key pillars are B and D. Birth, so B and M, birth and marriage.
Marriage. Okay.
Birth and marriage. So when you become a family member by birth, become a parent, or you become a step parent, or you become what do you call it? By birth, so parent and child. But then you can also choose to become a family member by way of marriage, marrying into that family. So then all the people in that family have become your family members. So that is how a lot of people became family members of EU nationals.
Okay.
And if that basis of family membership is taken away, ideally, once it's taken away, then the person ceases to be a family member. But what
Yeah.
about the right they acquired? And so the law says that the right they acquired after becoming a family member will stay with them, even after ceasing to be a family member.
Okay.
And so, what are the rights? The right to live with that family member by way of residence in the UK.
Okay.
And so a family member as a parent, a family member as a child would have attained or acquired a right and have been given pre-settled status or 5 years visa under EU. Somebody
Mm-hmm.
would have married into the family, and the person by way of marriage would have also been given 5 years pre-settled status. And somebody after marrying into the family can also bring other family members who through that marriage have become family members of that person. And they all become lineage, what we call descendants. Now, as a result of whatever that can happen in life, the marriage is no more or the birth is no more. And what takes away birth is death, isn't it?
Yeah.
So where there's death, the person's relationship is gone. And where there's divorce, the person's relationship by way of marriage is also
Marriage
gone.
is also gone.
So is it fair to say that because of death, your familiar relationship should also go with death? No.
No.
And should we also say that as a result of divorce, your rights acquired under that relationship should also be taken away? No. Now that's the beauty of EU provisions, because it looks at the human side of things and not just the law itself.
That's the law.
If
Okay.
somebody was just a British citizen or somebody with indefinite, once there's death in extreme cases, of course, they will have something right. But once there's divorce, for example, you can't have your right retained if your partner was British. But
Mm-hmm.
under EU, they say that yes, if the person has divorced you for whatever reason, your right can still be there.
Stay with you.
And that fact that there is right to still exercise is the retention of right. And
Okay.
so under Regulation 10, it talks about how somebody can exercise their right even after they have lost the relationship or their familiar relationship or right.
Mm-hmm.
And so we've looked at the basics, how it's acquired, how it happens, but then we are going to look at how then do we use it in a way to maintain our residence in the UK.
In the UK.
Hence, application and the EUSS provisions on the basis of retention of right. So, producer will take us to the rule book, and that is the marking scheme for caseworkers when they are checking application. So, producer, take us to page 6, and Brakuku will do us the honors within 3-4 minutes. We'll then move on to the discussions. So, free movement right, retain right of residence, and this was published in 2020. So,
Okay.
Brakuku,
So we
take
go
us.
to page 6. We go to page 6 of the document, and it starts, yes, EU settlement scheme. It reads that after the UK leaves the European Union, EU free movement will be brought to an end, and all documentation issued to European Economic Area and Swiss citizens and their family members under EU law will cease to be valid. After free movement is brought to an end, EA and Swiss citizens and their family members will require UK immigration status in order to remain in the UK. The EU settlement scheme provides a basis consistent with the withdrawal agreement with the EU published on 19th October 2019 and with the citizens' rights agreement reached with other European Economic Area countries and Switzerland. For EEA and Swiss citizens continuously resident in the UK and their family members to apply for the UK immigration status, which they will require in order to remain here beyond the end of the transition period of 31st December 2020. It
So,
continues to say that.
if you pause there, Brakuku, so this is the beginning of the EUSS scheme.
Okay.
Yeah, the whole EU, what is EU, what is EU settlement scheme? It says that those who want to remain must have immigration status, no longer freedom.
Okay.
So everybody was asked to apply either 5 years or indefinite, depending on how long they've been in the UK for. And so we move on. But we've understood that for somebody to say that I want to apply for settled status, it means that they've already been given pre-settled. And this conversation is about somebody who is making an application to stay in the UK on the basis that they have retained their rights and they are going for indefinite leave to remain. So we'll move on to the next part.
Okay. So retained rights of residence, that's the next part, as lawyer has indicated. This page tells you how family members of European Economic Area (EEA) nationals can retain the right of residence in the UK. And then immigration EEA regulations 2016, the 2016 regulations, certain family members of EEA nationals who are exercising free movement rights in the UK are allowed to join or accompany the EEA national in the UK. For more information on the rights of such family members, see the links as provided below: free movement rights, direct family members of EEA nationals, and extended family members of EEA nationals. So it was talking about the regulation 10. Now,
Right. Yeah, continue.
yeah, the regulation 10 says that the regulations also provide for certain family members of EEA nationals to retain or keep their right of residence in the UK under regulation 10 when the EEA national either dies or ceases to reside in the UK, and thirdly, divorces their spouse or dissolves their civil partnership. The family member is defined as the parent with custody of a child of the EEA national, where the child retains the right of residence. The former spouse or civil partner of an EEA national has custody of, can you roll up for me, please, quickly? Is custody of a child of the EEA national. The former spouse or civil partner of an EEA national and has the right of access to the child under the age of 18 of the EEA national, which must take place in the UK. And then it says the family member of someone who has retained the right to reside in other ways specified in Regulation 10.
Right.
Yes.
Yeah. So we've understood the key basis
Mhm.
where somebody can retain his or her right. We've already stated that by death or by divorce.
Right.
And of course, somebody might also be living in the UK and decide not to live in the UK any longer. There's also opportunity for the member who decide not to leave the UK with the family member to retain a right. But the key thing is, what shows that you have retained your right? You have to provide death certificate of the family member or divorce certificate of the marriage that
Okay.
was with that family member. So let's say, we're going to take a scenario, and our case scenario subject is Johnny. So let's remember Johnny.
Okay.
Johnny is married to um, an EU national. So we look
Okay.
at just two quick ones. So Johnny was married to Mary. Simple. Johnny was married to Mary, and Mary was from Germany, EU national. They lived in the UK. As a result of that, Johnny was given pre-settled status, and he was given in 2021. They married in 2021, and he was given in 2021. Um, Before he was given, they had already been they married in 2020, but he was given in 2021. So he qualifies and he was granted. Then something happened, relationship broke down. He was issued with a divorce certificate in 2025. John wants to apply to retain or want to apply for settled status. So let's check whether he's first due. Could successfully apply for settled status on the basis of your retained right. So John wants to apply for settled status. He's no longer with Mary. So he doesn't even know where Mary is at the moment. So we check. One, because it's settled status, John will have to apply under paragraph EU 11 of Appendix EU to the immigration rules, which says that if you're applying for indefinite leave to remain under EU provisions, you have to show that you've been resident in the UK for 5 years. So let's check. John married in 2020 in the UK, and he married Mary. So we check to see whether he's been resident in the UK for 5 years. Calculate 2020, so 2021, 22, 23, 24, 25, 26. It appears that he's done more than 5 years already in the UK. So he has met the 5 years residence test, ticked.
Right.
And because he meets the 5 years residence test, he qualifies to apply for settled status. But then he will be checking to see whether other things are also in place. What if John was brought from abroad by Mary because they married in 2022 and he came in 2022 after their marriage, and Mary is no longer with John, and John is saying that because we are divorced, I want to apply for my indefinite leave to remain because somebody has told me that if I have divorced Mary or Mary has divorced me, then I can apply for retention. Could John apply to remain for indefinite leave to remain if he entered the UK in 2022?
2022 to 2026 is 4 years, and he will not have lived here for 5 years.
So even though he may meet the requirements, specific things he needs to provide to show retention
Mhm.
criteria, he's not able to apply under EU 11 for indefinite leave to remain because he has not been resident in the UK for 5 years.
For
And
5 years.
community members, let's take note. So this is one person. In one way he qualifies, in another way he doesn't qualify
He does not
on the
qualify.
basis of length of residence. So let's bear in
Mhm.
mind. Because a whole lot of pocket lawyers will say, "Oh, go and apply because you are married, you are no longer you have divorce certificate. Oh, do you have divorce certificate? Oh yeah. Oh, then I'm going to apply for indefinite." But it's not just about divorce certificate. It's also about how long
The
you've lived
from
in the
time they
UK
are
for.
spent in the UK.
Good. So you can see that if John could show 5 years residence, then his potential in terms of the basis of the application. And
Mhm.
if John hasn't, then he doesn't even have to start the application in the first place
At
because
all.
he's
Yeah,
not
because he will be refused.
meet the requirement Okay. Now we know that John met the requirement because this John was in the UK already, married in 2020, and from the date of marriage, he's already done 5 years.
Mhm.
Now, the next rule is that you have to show that you and your family member have been living in the UK for 5 years.
Okay.
This is where John will say that, hang on, we lived in the UK for part of the 5 years. Because if John married in 2020, got his pre-settled in 2021, it means he was living with a wife, right?
Yeah.
So John cannot say he has never lived with a wife for 5 years. He will say he has lived with a wife for part of the 5
Part
years.
of the 5 years. Yeah.
It means he has to prove that he lived with a wife for that part of 5
Part
years.
of the 5 years. Yeah.
What if he's not able to provide anything?
That would be a tricky one.
But he
Because
doesn't have anything. It means he hasn't lived with the wife at
he
all.
hasn't, yeah.
Exactly.
Because then
And that would be difficult.
the caseworker will not have anything to indicate that you tick that box where you have lived with that person for at least part of the 5 years. So they become tricky.
So what we are saying here is this: because you are proving that you lived with your partner before divorce or before death, or the family member before death or divorce, you have to demonstrate that you lived with a person. And so the learning here is that if you are going to make an application on the basis of your retained right, you must provide residence evidence for yourself and for your family member showing the same address for that period that you were with that family member.
Mhm.
Very important.
Okay.
Right.
So this
Then,
will apply to the person who has decided to not live in the UK anymore, and you were dependent on this person either as a parental or in a parental relationship or in a marital relationship. If the person moves out of the UK, you would have to give evidence that part of that 5 years you were living with the person.
yes, so yes, but it cuts across all retention analysis.
Mhm.
So the
Okay.
moment you say that I'm applying to remain in the UK because I have retained my right, or you are saying that you are no longer with that family member.
Okay.
If you are no longer with a family, because if you were with a family member, then you have to show living with the family member for 5 years.
Mhm.
But if you are not with a family member, how can you show 5 years? You can't. So you only
Yeah.
show the part you were
The
with,
part of
you
the
were with the
5 years
family
that
member.
you were
Exactly.
with that
It could
person.
be 1 year, it could be 2 years, could be 3 years, depending on when the event occurred that you ceased to be with that family member. Very
Okay.
important.
Okay.
Then we move on to showing that you are no longer with the person. So if you are no longer with the person, then of course you have to provide something to replace that person. So if this person was a family member by
Mhm.
birth, then you have to and this family member is no longer in your life, then you have to provide death certificate to show that this was my family member, but this family member is no longer in my life. Death certificate if it is separation or the relationship broke down as a result of death. You have to
Mhm.
provide death certificate. What if you tell the caseworker that I don't have a copy of my mom or dad or family member's death certificate? Would that be a genuine excuse?
No, because if you were living with the person, you would know from when the person passed on that this person has passed on. You would have been part of the burial and funeral process. So obviously, such documentation you would have cited.
Good. So there's a Latin expression called habeas corpus. Habeas corpus is usually used in criminal proceedings where we say that we have to provide the person either dead or alive. Yes.
Okay.
Now, under EU retention proceedings or arrangement, all they are saying is that if you can't provide the body, provide the document.
Provide the certificate.
Simple. So if you can't
Okay.
provide the person and you can also provide the death certificate because you are saying that your family members are not giving it to you,
Then you
I
have
think
no evidence.
Exactly. So it's important you provide something to replace the body, which is no more. All right.
Okay.
And that's the
All right.
death certificate. Now, if it is about divorce, again, the person is no longer in your life. So you have to provide evidence that the person is no longer in your life because this relationship is broken by way of divorce. So again, divorce certificate.
Certificate.
Yes. So it's also important. A
But
lot of people are able.
what if the divorce has not really ended? What certificate or what documentation would you be able to provide?
So the rules say that if the process has not concluded, then
Mhm.
you have to provide evidence that the process has started.
Okay. All right.
And that is why you can see that depending on which part of the world the proceedings are taking place. In the UK, the moment you start divorce proceedings, you get evidence of process starting, what we call application for divorce. And
Mm.
you can rely on the application from the paper from the court as basis of your application. But if you are doing it from other parts of the world, Ghana, Nigeria, Jamaica, US, or wherever, and the process is not proving that it's initiated, then you only have to wait till the process is over, isn't it?
Mm.
Yeah.
Oh.
So it's a
So it
whole.
depends. It depends on, as you would say, it depends on the jurisdiction.
Yeah, no. What it's not. It's not a case of it depends on the jurisdiction. If somebody says that okay, my divorce proceeding has started in the country where we married, let's say
Mhm.
Ghana or Nigeria, then they have to provide the court papers.
Okay. Okay. So at least something to prove that you have started the process, though it hasn't concluded.
Yes, and you can. So you don't have to wait for the process to conclude or end. You can rely on the paperwork, the application
Mhm.
itself, and the fact that proceedings are ongoing to apply if you have done 5 years and you qualify to start the settled status application.
Well, folks, if you just joined us, we're live on BWTV, and the program is the Community and the Law. This afternoon, we are looking at a very interesting and important topic: how to successfully apply for EU settlement scheme based on the retention of rights. Lawyer Charles Asma, resource person and guest, is taking us through the definitional issues, how to prove that you can retain your rights, the relationship, whether a parental one or a matrimonial one, if it's broken down, evidence that the relationship is broken down. And then if you do not live with the person within the 5 years, you must show evidence of the fact that part of the 5 years you were with the person. And what do you need to show? Your marriage certificate and anything that really indicated that you were living with the person before the breakdown of the relationship. I know you may have questions, even though we haven't finished with the discussion. We'll be looking beyond having proving all that and how the application is going to be done. If you have any question, you can put that in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV, or you can send a text to 07399208468, WhatsApp message or a voice note 07399208468. And the telephone lines will be activated when we allow for questions, and that will be 0208 493 7345. 0208-493-7345. If you are new, like the page, click on the subscription button and the notification one as well, and then we will send you notification whenever we put any content on our social media platforms. We will be right back after this very short break to say thank you to BWF Solicitors. And when we come back, Laura Charles Osma will continue with a lively discussion. And I know you're making notes, you noting that somewhere to get your questions and all the other bits ready for him as well. It's the Community and the Law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back and thank you for sticking around. We so appreciate that. We coming your way, courtesy of BWF Solicitors live on BWTV, and we are live on Facebook and YouTube at BWF Solicitors and at BWTV UK. Send us your text, your questions in the comment section down below on both platforms, or on 07399208468. The lines, when active, you will be calling 0208 493 7345. This afternoon, Lawyer Charles Asma is helping us look at a very interesting discussion how to successfully apply for an EUSS settled status under retention of rights. Last one, yes, we looked at the qualifying criteria. We're looking at living in the UK for 5 years continuous, when you may be able to do that, or retaining your rights and saying, I've lived with the person, the relationship is broken down either through death or divorce, and I have evidence to show that I've lived with the person part of the 5 years that I need as a qualifying period. What else do we have to look at?
Yes, so in terms of requirements, one, your family member was granted visa or residence under EUSS scheme.
Mm-hmm.
In a sense that if the person was not living in the UK per the regulation, because the regulation said that every member, every EU family, every EU nation national must apply to remain in the UK if they wish to stay. So
Yeah.
if the family member did not, or the EU national did not apply to remain in the UK or to stay in the UK, then they cannot be what we called relevant sponsor.
Okay.
So the person who is sponsoring you or could have sponsored you must be a relevant sponsor. So you have to
Okay.
provide their own 3434 number.
Okay.
The 3434 number is the application that they submitted for which they were granted either pre-settled or settled. And so they are living in the UK as family members, that is, as EU nationals. That is why you qualify to remain with them as a family member.
Okay.
So imagine you want to remain in the UK under EUSS, but your family member who is holding your hand has not chosen to remain in the UK, then can you remain in the UK?
Well, the person's left you, so you are suffering that predicament unless you can show that you had that kind of relationship with them within the 5 years. Then you can retain your rights, isn't it?
Yeah, okay, yeah, so apart from that relationship bit, let's assume that you are my family member. You
Hmm.
are giving me everything because you are from EU, let's say Germany.
Hmm.
But when they said you should apply to remain in the UK under
Oh, you
EU,
didn't. You
you
didn't.
didn't. Whether you
Yeah.
forgot or you couldn't be bothered, you didn't.
Hmm.
What it simply means is that you are in the UK illegally.
Yeah. Because the
So
law says that you should apply for immigration status.
very good. So that you'll be given evidence that you have applied. So if
Hmm.
you don't have evidence that you have applied, can I request to be with you so that we stay in the UK?
No, you don't have a leg to stand on. How can I be with you?
Exactly. And so one of the requirements when applying is that provide evidence that the person who is sponsoring you or who you say you have retained your right with had
Hmm.
a right in the first place.
In the first place. That's right. Yeah.
Because if they didn't have a right, then how would you have a right?
Hmm.
So evidence that the relevant sponsor was indeed a relevant sponsor. And that's why the law says relevant. Because there
Relevant.
are a
Yeah.
lot of sponsors, but not all of them are relevant for EU processes. Because
Hmm.
after Brexit, every EU national was asked to apply to remain or leave. And so if you chose to remain, then you would have become a relevant EU national.
Relevant. Yeah.
So you need evidence of that. And what do you need? You need a copy of their pre-settled status letter or a copy of their settled status letter. So when you
Okay.
are applying, they will ask you to enter the number of the 3434 of your sponsor. And you
Hmm.
also have to provide your own number. If you claim you are applying for indefinite, that means you've been given 5 years already.
Hmm.
So they will ask you to provide the UA number or your residence reference number 3434.
Hmm.
Or if you don't have it, what does it mean?
Then you did not apply to stay here.
Yes, it means you didn't have pre-settled. So how will you apply for settled?
Yeah.
Yes,
Because you don't
so
have a leg to stand on. How come we will ask you to move forward?
exactly. How can you move forward? So the
Mhm.
learning is here is that if you are applying for certain status, please go and check the decision that came for the pre-settled application you made and
Mhm.
look for the number on it. And that is your reference number, which you
Okay.
need when
We will need
applying
for that
here. All
application
right.
for. Okay.
So we've touched on all that. You have your passport, you have the sponsor's passport copy, you have your EUSS number, you have the sponsor's EUSS number. You come to evidence of living together for 5 years, or evidence of living together for part of the 5 years because there was a break in relationship. Then you provide evidence of the break, evidence that your relationship is broken, divorce, or death certificate. Then you put in your application. And once you ticked all the boxes, it becomes a matter of assessment by the caseworker.
Okay. Well, the caseworker is doing the assessment, and I know there are criteria that needs to be met. When you have met all these criteria, my usual question is, does it then become a tick box exercise where you have met all that? So obviously you qualify, then your application will be successful. Is it as straightforward as that?
Yes, it's a tick box exercise.
Mhm.
And that is why if you are refused after doing everything that the law says you must do, you have a right, and as a matter of fact, a very strong right to challenge that they've made a mistake.
How do we challenge these things? Going to court, admin review, or what?
Usually appeal. But if you are told to go for admin review, then you go for admin review. As a matter of fact, you can start with admin review and later go to court, you still have a remedy under. So the main thing is to appeal the decision if you are right. But you see, the problem most people have is that recently somebody came to me, told me that, lawyer, I'm in trouble. What's the trouble? Somebody applied for me. The person was my pocket, was a lawyer, but not a practicing lawyer in the UK. I think the person was somewhere in Ghana and was doing it for them, for this the person, put in the application, used documents that the lady had no knowledge of, submitted, blah, blah, blah. The lady was given 5 years, and when she was going for indefinite leave to remain, using the divorce certificate on the basis of retained right, she was told to explain that when she was applying for 5 years, she used documents that today or now or at that point, they have found out that it was not genuine. She has to provide explanation. And she gave it to another lawyer, and the lawyer used her own discretion to respond. And it turns out that there have been contradictory messages all over the place. She came to me, she said, lawyer, so what do I do? I said, well, if you are going to appeal, you have to provide, of course, that you lived with your family member up to the point of divorce. And if you say your family member is still with you, then your family member must be with you in court as a witness to support the appeal. Again, because they raised doubt about that document, you have to address that and provide an alternative explanation that what they are saying is not the case, and prove that indeed it's not the case, because they said that there were Monzo bank statements and they checked and realized that those Monzo bank statements were not genuine. So what I told her eventually, said, so lawyer, so what do I do? I said, well, it's a decision you have to, but my professional advice would be that if you are not sure that you have a case in court, then there's no point fighting. Yes, your pre-searching status will end somewhere in May. And so what you can do is that once May comes, they are going to renew for you automatically. But at that point, you can also apply again for another settled status. You can always apply again and take your time and address the problem that came earlier on in the subsequent application. So that is something to be considered. So the person took the advice, okay, in this case, let me give myself time to be able to organize myself and apply again. But you see, these are some of the things that can call for refusal. And whether you can succeed in court or not depends on whether your case can be made out by yourself.
Well, I would reiterate my point. A word to the wise is always enough. As a layman, give your work to a qualified artisan to do. And I'll recommend BWF solicitors for you to deal with, so they can ask all the relevant questions, ask you to provide the necessary documents so they can put in a very cogent application. And once we have answered all the questions on the sheet and ticked all of them, your successful application will be yours in no time. How long does it take to get a response?
Ideally, 6 months. It can be longer, it can be earlier.
In fact, this 6 month thing, I think people should take their minds off that. It could be longer, can't it?
Yes, as I said, can be longer, can also be earlier. But a standard, maybe 6 months.
Maybe 6 months. Well, folks, if you have any question you want to throw at Lawyer Charles Asma, please do not hesitate. Put that in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV, or you can send a text 07399 208 468, or now I'm going to activate the phone lines 0208 493 7345. Now check the social media handles. But before we go there, the caution I gave you earlier on was about giving immigration advice when you are not qualified to do so. Remember, according to sections 84.1 and 91.1a and B of the Immigration and Asylum Act of 1999, it is a criminal offense, really, to provide immigration advice or services in the UK if you are not regulated or otherwise qualified to do so. Our friend Peter did something for Shirley some time back, and it's put Shirley in trouble, I should say. He's a law graduate, Peter, and he's been advising people in the community on immigration matters. He takes up cases by completing and submitting applications for people, often at a little fee. On one occasion, he advised our friend Sarah about an EUSS application and agreed to submit the application for her. Sarah's application was rejected because there was no reasonable ground for delaying an EUSS application until July 2025. Sarah has raised a complaint against Peter for the rejection of her application. So Peter is in trouble. Let's see if we can give him some good advice. We're going to say that it is not Peter's fault that Sarah did not have any good reason for the delay in submitting her EUSS application. If Peter can show that he advised Sarah about the likely rejection, then Peter should be all right. Or are we going to say to him that Peter has committed a criminal offense and is likely to face imprisonment or a fine or both because he provided an immigration advice and service when he was not qualified to do so? Think about that. I'll come back and pick up your answers. But there's a time for us to be interactive after this short break for our social media handles. Okay, we are back. Thank you very much for joining us. That was a quick and a short break. How do you successfully make an application about retention of rights and EUSS and all that? We've discussed that. If you have a question, don't hesitate to put it to Lawyer Charles Osman. He's going to help you. And if you have any other question, yes, you can bring it on, and Lawyer Charles Osman will be gracious enough to do that for you. Uncle Charles, this person says that Junior Agenda is the name. He's in the process of applying for naturalization and just got stuck at the parent details where they asked about their dates of birth. The issue is he doesn't have access to the parents and doesn't know their dates of birth. How does he proceed with this application? Can you help?
Okay, yeah. So, Junior, on the application, go down where they've asked you a question about the parent, the first parent. Go down after the last question because it says the name, date of birth. Don't provide anything at all if you don't have the details. There's a point where it says that I don't have the details or I prefer, there's something like that. It's a link. So just click on that. Once you select that, you move on to the second parent. I don't have the details. Select that. That's it. Then you move on.
Lawyer, that brings me to this point. Sometimes when people are completing forms and there are points where they say gender, nationality, and ethnicity and all that, and then part of the options, it says, I don't prefer to say. For date of birth, can I say I don't prefer to say?
Is it your date of birth or somebody's date of birth?
Somebody's in this situation.
Well, somebody's in this situation is different from the context you gave.
Well, I was going to come back to that anyway.
So somebody's situation, if you don't have it, you don't have it.
Okay. But in your situation,
you can't say you don't have it about yourself.
Or I prefer not to say.
Why do you prefer not to tell us who you are, and yet you want us to know you and give you a visa?
Well, I get it, but I've seen where about ethnicity, nationality, and
Yeah,
sexual orientation,
yeah.
people prefer not.
Those ones are for survey and employment applications.
Okay.
When there's a survey being carried out or
Hmm.
employment application, they ask about. So it's beyond the basic information.
Okay.
This one is extended information about you, and they tend to be private and intrusive.
Okay.
And that's why they give you a choice.
Okay.
Yes, nationality. Nationality, you just tell them what your nationality is. But race goes beyond nationality. And if you
Okay.
don't want to be associated with or to be known to be of this race, a particular race, you say, I prefer not to mention. Or
Okay.
sexual orientation, which is also
Mhm.
private and intrusive. You can choose not to disclose because it's personal.
Okay.
So
Okay.
where you are given a choice, you choose what is okay for you. But where you are not given a choice, then you have to give what you have to give.
All right. Well, keep them coming through. If you would want to call 0208 493 7345, you can send a text 07399208468, or keep them in the comment section down below, either on Facebook or YouTube. Vortex Games. My sponsorship license has been cancelled, but I haven't received any 60-day notice. Can I still do my 20 hours? Cobra Boy is asking why.
So Kobna says, as far has been cancelled, I haven't received 60 days. Can I still do 20 hours? Now, the 20 hours is with a separate employer anyway.
Mhm.
And if you haven't received the notice, it means your visa is still at least valid for
Okay.
now. And so if you are working for somebody 20 hours, you can continue. As a matter of fact, you can even continue to live your life or do whatever. The only problem will be with the current employer whose license has been cancelled. Because the current employer, once the license has been cancelled, then they are not qualified to keep you per se. On what basis are they keeping you? But if you are working for somebody on the side, um, my brother, look, if you think that you need to survive for now, you have to survive. But if you think that you don't really need it anymore, and so you want to just stop the 20 hours as well, then of course it's a choice. If I'm in your situation, because I need to survive, I'll continue to hang in there until the employer has told me that, you know what, you cannot keep working for us 20 hours.
Well, as it were, it's giving you the options. The choice is
Yeah.
yours, so you have to make that
Yeah,
decision.
there's no right. Such question, there's no right or wrong.
Mhm.
Yeah, so he has to do what is best for him. And what is best for him will be based on his personal circumstances. If the employer believes that you don't have a visa to be working for them, then they will ask you to leave. But if they believe that you have a visa to be working for them, then they will keep you. So it's not a choice that you want to stay or you don't want to stay. It's the employer that will let you leave or not, isn't it, Brakweko?
Mhm.
Yeah. So if the employer is not asking you to leave, well, you are
Right.
just the mercy. So
Well, keep them coming through, Kabra. Yeah, thank you very much for sticking around. J. Camo, you said you wanted to ask a question. So, yes, there's a time to do so. Perpetua comes in and says, I came to the UK in 2023 with a spousal visa. Next month, 11th of May, it is expiring. When should I submit my application for renewal? Today is the 4th of April, isn't it? And the visa expires the 11th of May. When can they put in an application, lawyer?
I came to the UK 2020 with a spouse visa. So this, I suppose, is 2.5 visa. Yeah. Yeah. So if 11th of May, then a month to 11th of May will be 11th of April. Give and take, I would say start from the 15th of April.
On Sunday from
Yeah, from 15th of April, the last 28 days, you are fine.
That's from Perpetual. Thank you very much. The next one is let's see who has another one. I'll keep saying keep them coming through, and we'll read it out for Laura to help you. I was here with my wife. My name is Bismarck. My wife told me to divorce, and she stayed at a different place, and I didn't agree to the divorce. What should I do? So the wife is asking for divorce. This person is objecting. I'm assuming, Bismarck, you didn't tell us, but I'm assuming you are dependent on your wife and asking for divorce. So you did not agree because, that's my assumption. If I'm wrong, please tell me. You did not agree because you feel that when you are divorced, you will not have a leg to stand on. And so you are not agreeing to the divorce. You're asking lawyer what you should do. I don't know if that's correct, but let's assume that's what you mean.
I mean, my wife told me to divorce. She stayed, blah, blah, blah. I don't want to divorce her. What should I do? She doesn't love you. So why are you forcing yourself? My brother, if the woman says that, you know what, I've had enough, I want to divorce you, the worst case scenario is that you refuse to sign the paperwork or to agree to the application for divorce. Then the process will go for contentious proceedings. That means both of you have to be present and argue it out, and the court will decide whether it is fair for proceedings to be continued or for the divorce to be issued. But you can't say that I don't want to do it. She's forcing to divorce me. What should I do? Talk to her and let her agree that you love her so much. But I think if it's beyond this simple question and simple response, then please speak to a lawyer, get in touch. Because I think there's more to it than what you are saying. Okay?
Okay, so now let's go on to, I think we have somebody on the line, lawyer. So let's see if we can pick up our call. Hello.
Good afternoon, boss.
Good afternoon, boss. How are you?
But I FM Peter, if you hear me.
Yes, Peter.
More questions.
Patrick, you too.
Lawyer. We get a Ghana passport by more EU passport. And me definitely having a make it by more Ghana academic government. Maybe said that my wife is so current age must maybe said send me to Kafanaba, quantum crown or to
Okay. Mama lawyer and you are but it's an income.
But you.
Okay. All right.
It's a kind of me you are no bro for man. And I brought none my uncle brofuna obi nsi yanka ye I. Yo. So our brother is asking, and for purpose of clarification, please help me. So you have indefinite leave to remain, or you are waiting for indefinite leave to remain decision?
I'm waiting for indefinite leave to remain decision.
Right.
My wife has.
Okay, your wife, don't worry, help me here. Your wife has indefinite leave to remain.
Yes, please.
Are you applying for indefinite leave to remain based on your wife?
Yes, please.
And is your wife a British citizen or an EU national?
An EU national.
Your wife is EU national?
Yes, please.
So you applied for settled status?
Yes.
All right. Okay, good. Your wife knows your children, right?
Yeah.
And your wife loves your children?
Yes, please.
And your wife wants her stepchildren to be with the family?
Yes.
Then she can apply for them to come under EU law because these are stepchildren. stepchildren of an EU national. So you can apply you under EU, not under standard. Because if you do it, you have to pay money and you do it under immigration rules. And you cannot bring them because of sole responsibility. But if she is going to bring them, that's the beauty of EU law. There's no argument about sole responsibility. All she will say is that I live with my husband has children, I play a role in the life of my stepchildren, I want my stepchildren to be here. Nothing about where their original mother is, and it's easier. Okay?
Okay. All right. Thank you, lawyer. Thank you very much.
Okay, thank you very much, my brother. Stick around and share the page as well, and spread it so people will enjoy and have the benefit of what you have had as well. We go on to the next one. We can pick up a call or put a text on there. Right. Keep your text coming through, your questions, your comments, and your concerns. Perpetua is saying, thank you, lawyer, for the response you have given us. Thank you, lawyer, for that. Thank you, Perpetua, also for participating in the program. Good afternoon, lawyer Asma and Oriku. If non-EU member has lived in the UK for 5 years and has divorced his EU partner and don't have enough evidence of his EU partner to apply for his settled status, will the Home Office refuse the application and curtail the rights to live in the UK, or they will give them another 5 years or give a non-EU family member another 5 years as pre-settled status? So that scenario where you are not able to prove all those things, then I think along the line you mentioned it will be renewed automatically for you. If it's renewed automatically, how long are they giving them? Another 5 years as a non.
The 5 years will be every 5 years.
Still as pre-settled.
Yeah, because they can't apply for settled status if they don't have the evidence to apply. So at least they can also ask them to leave the UK. So what they will do is to keep them on 5 years every 5 years. Because that's the law.
All right. Kevin, that's the law. The law is the law, and it works like that. Thank you very much for yours. Abdullah says, my visa will be due for renewal on the 27th of January 2027, and I'm to travel to Ghana next month. Can I still pursue my trip?
The visa is expiring in about a year's time, right?
Mm-hmm.
Even take 12 minus 4, 8 months. Of course, you can travel and come back, unless there's something you don't want to tell us.
Abdullah, hurry up, go home and come. 0208-493-7345, text 073-9920-8468, or you can put them in the comment section down below as people have done. This is a text message. I was granted indefinite leave to remain under EUSS as a spouse to an EU national in June 2025. However, before I was granted a pre-settled status in June 2020, I had overstayed my visitor's visa for about 1.5 years. I would like to find out if overstaying my visitor visa will have any consequences on my British citizenship application. How would that be treated under the character reference requirement? If yes, what are my options, please?
So, indefinite leave to remain under EU.
Mm-hmm.
However, before I was granted, I had overstayed. Okay. I went to apply for citizenship. Would this be an issue? The only issue would be if you entered the UK illegally. But if you entered the UK with a visa and you became an overstayer, overstaying does not necessarily affect citizenship. But entering illegally affects citizenship.
Okay. Right. Thank you very much, my friend that sent it on a text message, even though you didn't include your name. It's fine. Yes, we have had the opportunity to answer that. I have EU pre-settlement status. I got married in 2020 and entered the UK in 2023. My wife went to divorce me. Can I apply for indefinite leave to remain in years? I don't know. I don't know what you mean by
Okay, so I have pre-settled. I have pre-settlement status and got married in 2020 and entered the UK 2023. Okay. My wife was okay. So this person has been resident since 2023.
Mm-hmm.
So their 5 years anniversary will be 2028.
Yeah.
Now, even if the relationship breaks down, they would have retained their right anyway. So with the divorce certificate, he can apply in 2028 for settled status.
Oh,
However,
he's added some bit. He says, can I apply for indefinite leave to remain in 3 years?
oh, that I think he wasn't available when we started the conversation. If you apply for indefinite leave to remain, you should first meet the residence criteria for indefinite. The residence criterion is under paragraph EU 11 of Appendix EU to the immigration rules, which says that if you apply for settled status, you should show that you have been resident in the UK for 5 years. Even though you married in 2020, you never came to the UK until 2023. If you had come to the UK in 2020, then 5 years would have been due. But that's why I started by saying that your 5 years will be due in 2028. So you cannot do it now. They will refuse you and give you the pre-settled again.
Yeah. So you came in 2023, your 5 years is 2028. So in 3 years, it would be 2029 if we're calculating from now.
No, I thought he's saying in 3 years, or he's
In
saying
3 years.
no, that's not what he meant. That in 3 years phrase has two meanings.
Okay.
The first meaning is, can I do it when I have been here for 3 years? Because the 3 year will be 2026.
Okay.
So if you say to him yes, then he will only go ahead and do it because lawyer said I can do it in 3 years. What lawyer has to know is, what do you mean by 3 years? Do you mean in 3 years or 3 years after arriving in the UK? And that's the double meaning. So we are going to answer both. If you mean that 3 years after entering the UK, that will be 2026. That's not 5 years, so no. If you mean 3 years from today, that would have been 2029. And so that would have been overdue anyway, because you have to wait till 2028.
Okay. So, Frank, as you quickly provided the 3 years as an extra, drop something for us to know which of the two scenarios that lawyer has explained you actually meant. Thank you very much. We have Oluwato Sirene. Oluwato Irene. I should assume that. If I got it wrong, forgive me. Can my children still apply for indefinite leave to remain when they are 7 years in the UK?
And where were the children born? We want to know. If the children were born in the UK, if the children were born in the UK and they have lived in the UK for 7 years, yes. But if the children were born abroad and brought into the UK, then no.
Okay.
They can only apply for 2.5 limited leave.
Okay. Well, Abdallah has brought in something, but Abdallah, yes, lawyer says you can't travel because you still have 8 months on your visa. So if there is nothing that is untoward that you're not telling us, the answer obviously is straightforward. Kevin comes back and says, if you're a Ghanaian and you obtain a Schengen visa in the UK and you travel to Ghana, can you use the Schengen visa you obtained in the UK to travel to Germany and any other Schengen country?
You mean traveling from Ghana to the other Schengen country?
Mm-hmm.
To be fair, I will not be able to answer yes or no to that. My understanding with the Schengen process is that if you get a Schengen visa, you first enter the country that you want to travel to.
Mm-hmm.
And after that, you can travel to any other country. So if you go to Ghana and you travel from Ghana to another Schengen country because you have a visa, if they approve you, then you can travel. So if you are not sure, call the airline and ask them, I have a visa for Schengen country and I want to travel to France. I have already visited the first Schengen country that I got a visa for. Can I travel? Then they will clarify it for you Okay, Kelvin.
All right, Kevin.
Travel, especially if you are traveling from Ghana.
Okay. Oluwa Tosin Irene has come back, and it says, are we non-EU or EU as Nigerians? I thought EU are European countries.
What was the basis of this one? Are we non-EU or EU as? I don't understand. Do you understand that?
She came with a question earlier on. If we could pick that one up.
That was about the children, right? The child. Yeah.
Apply for when they are here 7 years in the UK. They are 7 years in the UK. Irene, your question, I thought it was related to this one, but it looks like there are two different things. If you could clarify.
This is, can my children still apply for indefinite when they are in the UK 7 years? And we have to understand, a child can be born in the UK and will be in the UK for 7 years. A child can be born abroad and will be brought to the UK and will be in the UK for 7 years. So what is the context? Where was a child born? And that will help to answer whether indefinite is yes or indefinite is no. But the second part to the point is out of place because it doesn't make sense. Are we non-EU or EU as Nigerian? I thought EU. Well, this doesn't say anything. Our brother was
Nigerian. Nigeria is not part of the EU economic area, the European economic area. Nigeria is not part of it. That's why I am thinking that it's not related to your previous question. If you could give us some further explanation, it will help lawyer give you the rightful advice. So please help. Abdullah Mohammed comes back and it says, I came with a spouse visa under immigration rules and my next renewal will be January 2027. Now I want to travel to Ghana for 4 weeks. Can I pursue my trip or I should wait? January 2027 is what?
Yeah, I think we answered him that he's got more time, 8 months. So if he wants to go on holiday and come back, he can. Provided
unless there's something he's not telling us.
Exactly. That's why I said that unless there's something he's not telling us, then on the face of the fact, he can travel and come back. But if there's something that he's not able to tell us, then I cannot respond beyond what I have understood. So he has to then get in touch and open up proper to us.
Okay. Well, keep on capping through. We've got a few moments more. I'll take about 1 or 2. Can I apply for stay for a woman that we just got married, but she's staying with her mom now, and I'm staying on my own? You're married, and your partner is staying with your mom, and you are staying on your own. Can I apply for a stay for such a partner?
Well, it appears that they haven't agreed to be living together as husband and wife. Until they agree to live together as husband and wife, that is when the law will see them as being in a subsisting relationship. At the moment, there's nothing to show that their relationship is ongoing. They are married, but their relationship is not ongoing. So our brother Kweku Danso, I think you need advice to discuss this. Normally, when people pick a surface of their point, of their story, and share with the public, of course, with us, they're only telling us what we should know, but there's more to it, and it's deeper beneath. So Kweku Danso, get in touch.
Yes, Danso, please get in touch. Any other person that will want further discussion and explanation to their issues, call BWF Solicitors on 0208 493 7340. Book an appointment to see any of the lawyers. Empress event. Yours will be the last one I'm picking before we go for our quiz. It says, my dad sponsored me to the UK as an EU priest status. Okay, I think we understand what you mean. But due to work, I'm not living with my dad. What do I need to prove when applying for EU settlement?
Well, the law has only changed for dependency, so she doesn't have to prove dependency. Even for example, she's working, she's making more money maybe than the father. And sometimes, how can you be dependent on somebody if you are able to earn that much? That was the problem before. It is no longer a problem. Case law now says that if the person is working and earning and able to look after themselves, it doesn't mean that the dependency is not there. But the dependency could be emotional and other needs. However, you are talking about where you are living with your family member. Yes, you are of age, you are this, you are that. But for the purposes of meeting the requirements, yes, you have your own home, but you also have a family home where your parents live and you live with them. So that first address should be important to this conversation. Okay, Empress. Empress, I think you have to get in touch so that you look at the best way to deal with the situation. Okay.
Right. I said I was going to pick up the last one, but Olu has come in, Irene has come in with some explanation. And she says that I meant, can they apply under the EUSS? I brought them in 2021 under student visa. 2021 to 2026 is not even 7 years, first of all, isn't it?
So they want to apply under EUSS based on who? Their grandparent or their parent? Olu, based on who?
I think I would advise, well, if you permit me, I would advise Olu to give you a call and I'll book an appointment to give you further details on that. Olu, if you don't mind, pick up the number 0208. It's under the screen as we have it. 0208 493 7340 and go and speak to Lawyer Charles Asma. He will take his time and unpick your situation and then can give you some very good advice as to what your situation is like and what you need to do. Well, folks, thank you very much for your comments. I know that most of you have a lot to bring in. Keep them coming through. We will get the lawyers to pick them up, and when there's enough time and room, we'll get them addressed for you, or we'll use them for our next edition as well. It's been the community and the law. And earlier on, I gave you the nugget about people giving immigration advice and services when they are not licensed to do so. And according to sections 84(1) and 91, 1A and B of the Immigration and Asylum Act of 1999, it is a criminal offense to provide immigration advice or services in the UK if you are not regulated or otherwise qualified to do so. And we continued to give you the consequences of doing that when you're caught. Unqualified individuals offering such advice can face imprisonment and fines, on summary conviction to imprisonment for a term not exceeding 6 months, or to a fine not exceeding the statutory maximum, or to both, or B, on conviction of indictment to imprisonment for a term not exceeding 2 years, or to a fine, or to both. Then I said, I have this Peter boy who, as a law graduate, has been advising people in his community on immigration matters. He takes up cases by completing and submitting applications for people, often at a little fee. On one occasion, he advised one Sarah about an EUSS application and agreed to submit the application on her behalf. It was rejected. There was no reasonable grounds for delaying an EUSS application until 2025. That was the reason that was given for the rejection. Sarah has raised a complaint against Peter for the rejection of her application. Peter obviously is in hot waters, isn't it? Let's advise him. Peter, it is not your fault that Sarah did not have any good reason for the delay in submitting her EUSS application. Peter can show that he advised Sarah about the likely rejection. If he did, then he should be all right. Or Peter, we can tell in the face, has committed a criminal offense and is likely to face imprisonment or a fine or both because he provided immigration service when he was not qualified to do so. What do you think? Okay, I'll quickly pick up the answers as they are coming in now. Ebenezer Mwako thinks it's number 3. Peter has committed a criminal offense. Abed Talabi thinks that Peter can show that he advised Sarah, then he is free. Nana Faye says number 3, Peter obviously has committed a criminal offense. Yasewa thinks that it is not Peter's fault that Yasewa could not provide any reasonable explanation to her application being delayed. Betty Assuming says number 1, Peter is not at fault. That's what she says. Lawrence Wache thinks is number 3. Let's look at that. Number 3. And Derek Achampo comes back and says it's number 1. Let's pick up just 2 more. And for the sake of time, I will get lawyer to help us with the rightful answer and the right advice to give to Peter. Emmanuel Adua says Peter has committed a criminal offense. And then finally, Kobe Gate says is number 3. Lawyer, 1, 2, or 3?
Okay, Rakuku.
Yes.
Let's work through this together. We are going to do it the way lawyers do, or the way caseworkers do, or the way a law enforcer will do. So what is the law? Section 84. What does it say? To be able to offer immigration advice, what should you have?
You should be having...
you should be qualified.
You should be qualified. OSIC, being a solicitor, or being trained, and giving that qualification and recognize that you could give.
So the 4 people who can offer immigration advice in the UK are solicitors, barristers, OIC license holders, and SILEX practitioners, Chartered Institute of Legal Executive. 4 people. Now let's go to Peter. Is he one of them? What is his background?
Peter is a law graduate.
So being a law graduate does not make you a barrister, solicitor, SILEX professional, or OIC license holder, right? So Peter doesn't qualify. Then we move on to the action. What did Peter do? He advised and represented, right?
Saying he will complete your form, charge you small, and submit for you.
So he's offering immigration service.
Yeah.
What does the law say for people who offer immigration service without qualification? What does it say? It says that 84 says that you must qualify. And 91 says that if you don't qualify, if you haven't qualified and you do it, you are susceptible to imprisonment on summary conviction or on indictment, X and on and on. Does Peter have an excuse for what he did?
He's not qualified, so he has not got any excuse.
Did he do the job that he wasn't qualified to do?
Yeah, I completed Sarah's application and submitted on her behalf.
Yes.
Obviously, he would have charged her.
And even apart from charges, even if it was free, before doing the application, he would have advised Sarah whether it will work or not. So, for doing what you are not qualified to do, whether freely or at a fee, you are putting yourself at risk. And the law says that if you put yourself at such risk, you can be imprisoned. So the answer is 3.
Peter has committed a criminal offense because he is not qualified, as lawyer has indicated. And we have worked through the situation ourselves. And that's based on section 84(1) and 91(1)(a) and B of the Immigration Act of 1999. Section 85, Legal Aid, Sentencing and Punishment of Offenders Act 2012 also confirms that. So, Peter, sorry, you've committed the offense, unfortunately. So, if the complaint is raised against you, you obviously know the likely consequence that will come your way. Well, number 3 is correct. So those of you who selected number 3, you are right. Junior Agenda, I saw yours before we did the explanation, so I'll give it to you. Sylvester Fojo says, good job, Uncle. Thank you very much for Sylvester. But let's pick up the summary briefly because we got just about a minute more to go from Lawyer Asma. Then we'll draw the curtains down. Uncle.
Sure. Right. So settled status application and retention of right, you must show that 1, you were with the EU national, and that the EU national had EUSS application granted. And 2, that you have been granted pre-settled status and you have lived in the UK for 5 years from the date of marriage, if you married in the UK, or from the date you entered the UK, if you came after marriage, or if you came to join your family members, the date of entry. And if you were born in the UK before 2020 or in 2020, from date of birth, of course, residence. Because settled status looks at residence, it's important that you have to show 5 years residence. If not, the application will be refused. Now, because you are no longer with your family member, you have to show that something has happened and that you want to rely on that to apply because you have retained your right. What has happened could be death of the family member, or divorce of the marriage to the family member, or that the family member has ceased to be resident in the UK. In all these circumstances, you have to prove it. So if it is death, death certificate. If it's divorce, divorce certificate. It's difficult to prove that the family member has left the UK if you can't tell when they left and all that. And so that part may be difficult to prove. And most people will be able to prove death or divorce. Divorce, you can use the divorce paperwork, even if it is not yet concluded, or you can use the divorce itself if the process is over. Now, you still have to show that you lived with a family member before divorce or before death. And so you have to show evidence of living together with a family member, proof of address for you and proof of address for the family member before they died or before the divorce. And in all this, you have to prove that you meet the requirement. So you provide your passport, you provide a EU national's passport, you provide your EUSS pre-settled status reference number, you provide the EU national's pre-settled status reference number or settled status reference number. Evidence of living together with a person for 5 years or less than 5 years before the event occurred. And the event evidence itself, and you submit your application.
Lawyer Charles Asma, thank you very much. I will, on behalf of my numerous viewers, listeners, and clients alike, say thank you for your time this afternoon. It's a very valuable period. Folks, if you know how busy he is over the weekend, you would triple appreciate what the value of our time here on the Community and the Law is. So, Lawyer Asma, I doff my hat. Thank you very much for your time. God bless you and repay you in tenfold for whatever you would have lost for staying with us and helping educating the community. To BWF solicitors, what else can I say than to say super massive thank you for the opportunity you give us every weekend to come the way of the community, with the community and the law. Our producer has been Professor Ade. Shilankra and Panmododu have been doing the admin and the aesthetics. My name is Ulrich Kufripo. Have a good evening.